Assalamualaikum everyone. So today we are going to continue with our lesson, written sources of law. So we just reached the fifth basic feature of the federal constitution. So we're going to continue the sixth basic feature of the constitution, which is basic doctrines of the constitution. So basically there are three doctrines of the constitution. So the first one is supremacy of the constitution, the second one is rule of law, and the third one is separation of power. Alright, so supremacy literally means highest. So supreme, right? Supreme is the highest, the upper level, right? So there are two types of supremacy. Okay, so the first one is parliamentary supremacy, and the second one is constitutional supremacy. So let's look at parliamentary supremacy. Okay, so parliamentary supremacy is a type of supremacy that you exercise where you uphold whatever parliament says. Okay, so whatever parliament says, you go. I mean, they set the law, right? So whatever they say is the law. So that is parliamentary supremacy. Now, where can we see this type of system? Okay, so basically you can see this in UK, right, United Kingdom, where they exercise this kind of parliamentary supremacy. Okay, so in parliamentary supremacy means that the power of the parliament is unlimited. They can do whatever law they want, right? So no one's going to question them, because why? They are upholding the supremacy of the parliament. Okay. So when I say that no one can question the parliament for making that law, that includes the courts, right? The royal courts, church, even the monarchy, even the royal family also cannot question the law made by parliament. Okay, all right. So that's done with parliamentary supremacy. So what is meant by constitutional supremacy? So constitutional supremacy is a type of supremacy where you uphold the written document. For example, our federal constitution. So in Malaysia, we are exercising the supremacy of the constitution. We believe that the federal constitution is the highest law in the country, right? So any law that we want to make, okay, must consistent with the federal constitution. So any law that is inconsistent with the federal constitution must go. Okay, you cannot exercise at all if it inconsistent with federal constitution. Okay, so you can see this in the article 1 of the federal constitution, which declare that the federal constitution is the supreme law of the federation of the whole country, right? So anything that is done must be aligned with the federal constitution. Okay. Alright, so you can see this in the case of Ahtian versus Government of Malaysia, right? So you can read this case. What I'm going to point out is what the judge who presiding the matter, okay, he held like this. The doctrine of the supremacy of parliament does not apply in Malaysia. Here we have a written constitution. The power of parliament and of state legislatures in Malaysia is limited by the constitution, and they cannot make any law they please, right? So this means that whatever law, right, is restricted by the federal constitution. Okay, in a sense that you cannot make any law, right, if it inconsistent with the federal constitution. All right, so can the federal constitution be amended? Yes. Okay, the answer is yes. Federal constitution can be amended, right, by way of 4 methods. Right, so the first one is special majorities. Okay, the second one, consent of conference of ruler. Okay, the third one is consent of Sabah and Sarawak, and the fourth one is not requiring special majorities. Okay, so these are the methods or the procedure where the federal constitution may be amended. Okay, so this is provided by Article 159 sub-article 1, clause 1, and Article 161E, right, which provides that federal constitution may be amended by federal law. Okay, right. So let's see the procedure where we can amend the federal constitution. So the first one, requiring special majorities. Okay, so requiring special majorities is where um amend by a bill which receives the support of the votes of not less than 2/3 of the total number of members of each House of Parliament on its second and third reading. Okay, special majorities is where the vote must be 2/3. Okay, 2/3 of the of the members of each House of Parliament. Then you can amend the federal constitution. Alright, so for example, okay, special majorities is required for bills to amend legislation passed under Article 10 Clause 4, which allows the Parliament to make laws regarding the so-called sensitive issues. So any sensitive issues require special majorities before you can amend the provisions in the federal constitution. Okay, so that is the first method, special majorities. The second one is requiring consent of conference of rulers. Okay, so there are some provisions in the federal constitution which you cannot amend without the consent of the conference of rulers, right? For example, matters included under Article 37 Clause 4, which directly affects the privileges, position, honor, or dignities of the rulers. So matters concerning the royal family or the rulers especially, alright, must obtain their consent before you can amend the federal constitution. Alright, okay, move on to the third method, requiring consent of Sabah and Sarawak. So there are certain provisions in the constitution which requires the consent of Yang di-Pertua Negeri Sabah and Sarawak, especially matters included under Article 161E, okay, which involve citizenships, jurisdiction of High Court, religion, etc. Okay, right. The last method where you can amend federal constitution is not requiring special majorities. Okay, there are certain provisions which you can amend by ordinary law, which does not require special majority but only simple majority. Okay, for example, right, when you want to admit state to the federation, right, or you want to alter boundaries, or you want to change federal capital. Okay, let's say you want to change, you don't want Kuala Lumpur to be the federal capital anymore, you want Putrajaya to be your federal capital, then you don't need special majority to amend that. Okay, you can just simply using simple majority, then you can amend the you can change the federal capital. Okay, so that is those are the four methods to amend federal constitution. Alright, so so why we can amend federal constitution? Okay, because every day people grow, right? The country also grow, so you cannot just stick to what has been made over 60 years ago, right? So we need changes, but that changes cannot be drastic, right? So that's why the amendments to the federal constitution is needed. Okay, right. You can read about the Malaysian constitutional crisis, right, which later amend Article 121 of the federal constitution, right? So because of this constitutional crisis, right, we made amendments to Article 121. Alright, okay. So the second doctrine of constitution, so we finished supremacy of the constitution, so we're moving on to the rule of law, which is the second doctrine of the constitution. Okay, so what is idea of rule of law? Okay, idea of rule of law is that people are ruled by law and by law alone. Okay, so rule of law is against arbitrariness and wide discretionary power on the government, since wherever there was discretion, there was room for abuse. So basically what we're going to say, what rule of law is saying is that there are rule of law that people must follow. Okay, so you cannot just what you please. Okay, there are rule of law that you must abide, right? Okay, so in Malaysia, the rule of law was adopted as our third national principle, whereas our fundamental liberties were recognized by virtue of Part 2, Article 5 until Article 13 of the Federal Constitution, which is the fundamental liberties. Alright, so there are two main ideas that embodied the rule of law, which are central to liberty and freedom. Right, the first idea is to respect for legality by the government. Right, the second one is protection of individual freedom. Okay, let's see the first main idea which embodied the rule of law. Okay, the first one is respect for legality by the government. Okay, so there must be a government of laws, not of arbitrary power. Okay, so respect of legality is evidence in there is supremacy of law and predominance of the legal spirit. Okay, there are controls on executive discretion. The courts are easily accessible to the people. There is no retrospective legislation. Okay. The second one is protection of individual freedom. Okay, so this idea said that there should be constitutional protection for civil liberties, for example, personal liberties. Okay, the second one, right to equality, okay, as stated under Article 8, right? The third one, the independence of judiciary should be guaranteed. So these are the main ideas of rule of law, right? Okay, let's say the third doctrine of the Constitution, separation of power. Okay, I think that you have learned this in school before. Separation of power, separation of power. Okay, where we separate those bodies into three bodies. Okay, which have their own functions, their own tasks to do. Right. So what are the three bodies? Okay, the first one is executive, the second one is legislative, and the third one is judiciary. Right, so there are three types of governmental functions. Okay, let's see one by one. So executive, as you can see, so executive are the body where they have the power to formulate policy and carrying out the actual task of government. So who is executive? Okay, Prime Minister, right, YDPA, right, Cabinet. So those are executive. Okay, second one, legislative. Okay, legislative has the power to legislate, which means they have power to make, to alter, and to repeal law. Okay, repeal means they can say that okay, this law we repeal it, means we don't want it to be enforced anymore. So that means uh, that is the meaning of repeal. Okay, repealing laws. Okay, right. The third one is judiciary. So judiciary is the court system. Okay, the federal court, the court of appeal. So this is judiciary. Okay, they have the power to administer justice and they have the power to interpret the laws. Okay, so the legislative, okay, they create the laws, they make the laws. The judiciary interpret it in their own sense and in their own way to administer justice to the people. All right, okay. So why we need separation of power? Because if we just focus onto one governmental function, okay, there would be abuse of power. Everyone would be abusing their power. Everyone would be tiring. Okay, so that is why we need separation of power, so that every governmental bodies, okay, they would not intersect into each other's functions. Okay, so they know uh what they have to do. Okay, right. So purpose of the doctrine, as I said lah, right, to avoid dictatorship, to avoid abuse of power. Okay, and also to safeguard liberty of the citizen. Right. Okay, application of separation of power in Malaysia. Okay, although we have separation of power in Malaysia, but we do not exercise it in whole, you know, means that we did not exercise it in a way that is very strict, right? Not like that. So in Malaysia, basically, executive and legislative, you could say almost, they are almost the same body. Okay, usually they are the executive and they are the legislative, but the judiciary remain independent as they are now. Okay, you cannot in any way try to influence the judiciary. Okay, all right, so let's see the relationships between these three government organs. Okay, the first one, executive versus legislative. Okay, right, executive versus legislative. There is no separation of power between executive and legislative. Okay, because why? Because we are practicing cabinet type organization. Okay, cabinet type of organization, right? So that's why we do not have specific separation of power for executive and legislative. Usually they are the same bodies. Okay, all right. Okay, let's see the relationship between executive versus judiciary. Okay, although these two government organ is very different, okay, you have to remember that any executive member, they cannot also become a judge, and a judge, okay, a judge also cannot become an executive member. So judiciary must be independent as a total. They cannot be a member of executive. They cannot be a member of an organization that relates to government or so on, right? So they need to be independent. Okay. However, executive appoints judges. Okay, which means that for judges, okay, they are appointed by executive. Okay, but once they are appointed, they are independent on their own. Okay, executive cannot tell them what to do. Executive cannot say that, okay, I appoint you as a judge, so you must listen to whatever I say. No. So a judge is independent right after they are appointed by the executive. Okay, so the third relationship is legislative versus judiciary. So very clear, legislative body is to make laws, okay, to amend law or to repeal law. On the other hand, judiciary, they are interpreting laws. Okay, interpret is different than making law. Okay, interpret is where when they read the law, so this is how you read the law, this is how you interpret the law. Okay, so by that interpretation, they decide all the cases based on their own interpretation. So if, let's say that if legislative say that is not what I intended for the law to be, or that is what in my mind when I make the law, that is not the judiciary's problem. Because why? The judiciary interpret laws according to them. Okay, they don't have to listen to whatever legislative said. So if legislative feels like their interpretation is wrong, the judiciary's interpretation is wrong, then they should amend the law. If the interpretation of the judiciary is wrong, right? Okay, all right. So that is the end of federal constitution. Okay, so I'm going to continue in the next video for legislation. Okay, thank you.